All right, welcome to the 2018 MSHA Agency Review and Outlook for the Conn Maciel Carey 2018 MSHA webinar series. My name is Nick Scala, and I will be your host today. I am the chair of the MSHA practice group here at Conn Maciel Carey, where we focus on representation for mine operators and independent contractors in all facets of matters dealing with MSHA, from citation contests as well as developing compliance strategies to fatality and serious injury investigations, as well as discrimination claims and agent liability investigations under the Act. I am happy that you guys have joined today, and thank you very much for jumping on for the first webinar in the 2018 series. Look forward to continuing to talk with any of you who have joined us in the past, and thank you to all those who have began joining us here in 2018. So today we're going to take some time and look at what can we possibly look forward to and what is the state of the agency as we begin 2018. Obviously, it's the second year of the new administration, and at this point we finally have our leadership structure in place at MSHA. Towards the tail end of 2017, we finally got the nomination for an assistant secretary as well as some of the other leadership posts filled. So we're going to take a bit of time and get to know who exactly is our administration for the MSHA side. We'll also go through a bit of an update on rulemaking and see, where are we at in terms of active rulemaking matters, as well as those that have been out there and we've been hearing a lot about, such as the workplace exam rule. We'll also review, how have the penalties changed now that the Inflation Adjustment Act is applied to the MSHA penalties. This happened in the last couple of years where we saw the statutory max drop and the statutory minimums increase a little bit for where we're at or what the penalties were under the Minor Act. And we'll also continue to get this increase each year moving forward. So as of January 2nd, there's a new set of maximums and minimums, and we'll review those. And lastly, we're going to talk about some areas that are programs to watch for changes now that we do have the full leadership structure in place and we get into the meat of the Trump administration's MSHA. So there, obviously nothing is concrete, but these are some areas that, there's been rumblings about changes or maybe ripe for that under changing of philosophy or changing in priorities at the agency. So to begin, we can take a look at who is our new Assistant Secretary. Well, the Assistant Secretary is now David Zatezalo. He was confirmed in late November, and he is now officially the Assistant Secretary of MSHA. He is, as is expected, with someone or a conservative administration, someone who has been in the employer side of industry. So he has 40 years in the mining industry, and that has ranged from being a rank-and-file miner to an engineer, both in the U.S. and abroad, and most recently as the CEO of a coal company, and that was Rhino Resources based out of West Virginia and Kentucky. And, there has been a significant amount of buzz in that the company did receive 2 pattern of violation notices at one of the mines while he was CEO. And this is something that I bring up solely because it really got a lot of attention during his nomination and confirmation process by opposition. Unsurprisingly, the confirmation followed party lines for the most part, and he was confronted on this many times, and even to the extent that would there be any inability to work with MSHA personnel who were party to those inspections or to inspections at his mine that resulted in significant enforcement. And the Assistant Secretary at that time, the nominee, consistently said that MSHA has a function to perform, and he understands that, and he looks towards making changes and improving the agency moving forward and how it interacts with the industry and its operators and stakeholders. So, when we're looking at this, what are some things that we heard from him in the nomination process that may give us an indication of where the agency could go? Well, he wants to improve enforcement consistency, which feels like something that every political appointee or person in power at MSHA says. or any federal regulatory body for that matter. But this is really something that is always a chief complaint from stakeholders, that there is a lack of consistency. And that may be from inspector to inspector or field office to field office for operations that have multiple locations, or even from district to district. So one goal, they are going to be looking at trying to increase enforcement, consistency, and interpretation of the regulations across agency as a whole. Now, obviously, this is going to come down to retraining or training the MSHA workforce. There has been a significant amount of turnover in MSHA. There's also been, especially in the metal, non-metal side in the last few years, a significant addition or reallocation of inspection resources. And I mean that is that they brought on a lot of new inspectors, as well as there was a shift of inspection personnel from the coal side over to metal, non-metal. So for these consistency approaches, or to improve consistency, there's going to be retraining, and that's how it has to go. There has to be a clear message from the top that has to be disseminated to all management personnel, who then can put it down the chain of command to the individual inspectors. So while that is taking place, we want to obviously continue to protect our rights and assert our rights when dealing with MSHA, and trying to make sure that we are keeping the inspectors on this consistent platform. So if we're hearing about new policies or new positions from MSHA or from their management personnel, whether that's at the district level, the national level, or at the field office level, and then we see inconsistent enforcement of that in the field, we have to push back. We have to, effectively contest those, bring it up in informal contest or informal communications with agency management, or go through the formal contest process. So those are kind of some areas that we need to keep at ourselves as an industry actively involved in this, because if there is consistency issues, MSHA needs to know about them in order to correct them. Additionally, he's going to look at increased use of technology to boost safety, and this includes monitoring the employer or the miner training and behaviors. And it is something that, there has been a switch, and even some of the rulemaking items that we're going to talk about later are going to circle around technology. Now, it's important to remember that most of the regulations that MSHA has are from the 1970s or before, when the Mine Act was authored and its previous derivations. So they are working with some outdated or some long-standing regulations, and obviously the technology has changed significantly in that time. So one goal that he has specifically mentioned in his term as the Assistant Secretary is to bring some of those technological advances into the regulations. And whether that will be by review of the petition for modification process, which we'll discuss later, or by reevaluating some of the regulations that exist at this time, that's yet to be seen, but it is an area that we're going to see trying to increase the amount of technology or the presence of new technologies that the stakeholders are using to align with MSHA compliance requirements. So another area that is got a significant amount of attention when it was closed up or combined with education field services is the reestablishment of small mines. And this is really providing more resources to industry to increase compliance and improve safety. And small mines offices is one that serviced, obviously the smaller operations and smaller operators around the country, and provided those compliance tools and some training tools on their behalf. Now, it's an organization or an office that was shut down. They want to bring it back. This has been specifically a push by several national organizations for the industry. And so it'll be good to see that resource come back out. So many people talk about back in the day when MSHA, was there to help you and was a partner in the mine safety and health, as opposed to just being there to regulate and just being there to write citations. And I think that's maybe a focus that the office or the administration now, they are going to put some emphasis into changing that. Another another new position is the Deputy Assistant Secretary for Policy, and that is Wayne Palmer. And that name might sound familiar because prior to the confirmation of Secretary Zatezalo, Wayne Palmer was the acting Secretary of MSHA, and prior to that he was the Chief of Staff to Secretary of Labor Acosta. So he is someone who has a brief history with MSHA and the Department of Labor, but he has a very well-versed history with the government and the political process and mechanisms. And, in terms of what he's going to do for MSHA, where he's going to be, we have to imagine that he is going to play a role in assisting in developing their rulemaking and their regulatory strategies, as well as promulgating new policies regarding interpretations and, again, that consistency and how they're going to go through that rulemaking process. He was, someone who was involved in the confirmation process and prepping the nominees for that within the Department of Labor. And he's also been involved in stakeholder outreach, which has been a big part of the new administration's focus in the last 6 months or so, is really re-engaging with the mining industry. So that is a role that he will continue to fill, and I think that as we move forward and as we get into the next couple years, we'll see Mr. Palmer's influence be more so on the side of how regulations are going to be moving forward, maybe what regulations are going to be a focus of MSHA's deregulation or removal or modification of outdated ones, as well as implementation of new policies on those. So how we get the interpretations and what kind of outreach or what kind of emphasis programs, those are all going to be part of this area of focus. Another one, and this is a particularly interesting addition to the staff, is Ed Elliott, and he has taken the position of Senior Advisor to the Assistant Secretary. Now, as most of us probably know, the metal non-metal industry makes up the majority of the mines under MSHA's jurisdiction, roughly 90% or more, and the vast majority of miners as well. Yet here we are with a coal executive taking over the agency, as is pretty normal as we look at the past. So the metal non-metal industry, rightfully so, expects or was hoping that there would be more of a presence for their industry up at the leadership level at MSHA. And what we get here with Ed Elliott is kind of that presence. He is a senior advisor, and he will work closely with the assistant secretary, and he is a very experienced safety and health professional from the metal non-metal industry. He formerly led the head of safety for the Rogers Group, which is a significant producer. He was very involved with the National Stone, Sand, and Gravel Association safety committees, and he will continue to kind of be a voice for the metal non-metal up at that upper echelon at MSHA. Excuse me. He has already stated that he's going to look to help incorporate some of metal non-metal's successes in safety and health and the practices and improvements that they've developed and implemented into the MSHA policies, as well as continue to monitor what the industry stakeholders are saying from that experience standpoint and making sure it gets communicated accurately. So he is a liaison for the metal non-metal industry in that respect, and it will hopefully give that part of the industry the voice that they are craving at the table, so to speak. And I expect that Mr. Elliott will continue to work with the metal non-metal industry as he has for a number of years. And I've had the pleasure to meet him several times, and have come away with the impression that he will continue to be an advocate on their behalf now that he is with the agency. So if we're looking past who the leadership is, let's look at what they're going to be implementing or what they're going to be pushing. Now, obviously, we're working off regulatory agendas that were created during the Obama administration, have now been taken over by the Trump administration and either changed or modified in some way or fashion. At the beginning of this, at the beginning of the Trump administration and the tail end of the Obama, the Part 100 reform for penalty and citations, which would fundamentally alter how a citation paperwork looks, how determinations are made, limiting the categories, also affect how penalties are assessed. That whole push was withdrawn and put in kind of on the back burner for an extended period of time, not unsurprisingly. Additionally, we saw at the beginning of 2017, the MSHA silica regulation also get withdrawn or put on long-term action items. And, what that means is those two big areas of focus that industry was bracing for at the tail end of the Obama administration are no longer on the radar. Maybe several years from now they'll resurface, but for the time being, Part 100 reform and silica regulation reform for the MSHA industries is not on the table anymore. So that is an interesting development, and also I would say an important development for the industry to be aware of. But with that, we have the fall regulatory agenda and what is still on the agenda, and that is several items in the pre-rule stage as well as a couple in the final rule stage. And so we're going to take some time to look through those and talk about each one of those. We have to keep in mind during this process that there is, the whole campaign push was there was a significant push towards a deregulatory agenda more than a regulatory agenda. We want to strip the burden on industry of unnecessary regulation. For the mining industry, this was specifically targeted at environmental regulations during the campaign. MSHA and safety and health regulations were not specifically mentioned, but there is still that mandate of a 2-for-1 rule. So if you're going to promulgate a new regulation, you have to get rid of 2 old ones. And also, all the agencies and all administrations and departments of the government are tasked with reviewing their record, rules, and their regulations and determining what can be removed, what can be stripped out, what can be streamlined, what can be done to reduce the regulatory burden, especially with outdated regulations or those that no longer adequately push forward safety and health, and that the environment, for MSHA's perspective, that the miners will not be put in any adverse positions with the removal of these regulations. So if we're looking at what is on this agenda, though, right now, the first one is a pre-rule stage regulation, and that is exposure of underground miners to diesel exhaust. And this has been something that's been on the agenda for a while. That's why I include the timetable right there, because we can see that there has been a good bit going on in terms of the request for information back in June of 2016, then public meetings, and then the end of the comment period extended and extended again, and then a reopening of the comment period, which is where we are at right now, or what was the most recent one. So MSHA in this case sought additional information on approaches that could improve the control of diesel particulate matter and diesel exhaust. And this is, again, specifically dealing with underground mines. So it is something that MSHA has, there is a rule out there, there is something in development, but they're still collecting information and feedback from the industry on the best approach, or maybe what needs to change in the regulation. So, that is where it's at in the most recent agenda. We'll see if there's going to be any change to it, whether it's going to be pushed forward or withdrawn as we go into the next regulatory cycle. But at this time, MSHA is still looking into this and what can be done to control the hazards from diesel exhaust, including the control of diesel particulate matter, which is an element of the diesel exhaust. but it is right now in the pre-rule stage. So there is not a regulation imminent that we're going to have to worry about going into effect in the near future, but it is something that still is going to be pushed forward by MSHA and is on their radar. The next pre-rule regulation is the reform of existing standards and regulations and a retrospective study of respirable coal mine dust rule. So the first of these two topics is the MSHA wants information regarding existing standards and regulations that could be improved or made more effective by accommodating advances in technology. And if that sounds somewhat familiar, it's because we were just talking about the goals of the incoming Assistant Secretary, and that was to bring technology to the forefront or use that to boost safety and health. It's looking for new techniques, less costly methods, and items that could be used to streamline the compliance and the safety processes. Excuse me. So that is an interesting and somewhat different and unrelated part to the second, but it also is related in that the next one, which is a retrospective review of the final rule to lowering exposure to respirable coal mine dust, including personal dust monitoring. They're linked because the agency wants to now look at information regarding technological advances that industry has put into place that may be more effective and more efficient without sacrificing safety and health for monitoring that coal dust, exposure to coal dust. And, excuse me, this particular part of the regulatory agenda has gotten a bit of attention and feedback as, the agency and the administration pulling back on lowering black lung protection. But really it's going on here is a review of the methods that were enacted in that law or in that regulation, and are there more efficient ways of doing so? There was a significant amount of pushback when the regulation on exposure to coal dust and the continuous personal dust monitoring, when that went into effect, that it wasn't going to be as beneficial as the agency thought it was going to be, that there was more efficient ways to do it, and that there was more advanced ways to monitor the exposure without having the personal monitors on individuals in the mines. Additionally, there was Executive Order 13777, and this was signed by President Trump on February 24th, 2017, so almost a year ago. And it was designed to enforce the regulatory reform agenda, and it was directing the agencies to review existing regulations for the cost of compliance and can they reduce the regulatory burden. And as part of that, it requested that stakeholders provide information to the agencies about which regulations could be repealed, replaced, and modified. And that is something that MSHA announced on October 23rd that they are going to be accepting comments on. And this is part of the process that is going through in the review of existing standards and regulations. So this is an opportunity for industry to notify MSHA of specific standards or regulations that they think are no longer beneficial or have become outdated, and those will be cycled in for the regulatory review and what can be possibly removed moving forward. As we mentioned before, the regulatory agenda will be interesting to watch in the next couple of years because it may be as much about what is being promulgated as it is what is going to be removed. So as we wait for that to take place, we'll have to be able to provide feedback to MSHA or to our industry associations who can then transport that information or deliver that information to the agency so that there is some guidance from stakeholders on what we would like to see occur or what changes we would like to see take place. Our last item in the pre-roll stage is a request for information, so just the very beginning of the rulemaking process, on alternatives to petitions for modification. So a petition for modification is a request to modify the requirements of an existing MSHA safety standard and to achieve, the purpose of the standards by different means than those required by MSHA. And, this is a process that, again, is gone through, and it's a legal process in that you have to file a request for or a petition for modification. It will go through a process of review with MSHA as well as eventually a process of review with an administrative law judge from the Federal Mine Safety and Health Review Commission if necessary. And it is very often something that is a modification that you're requesting because of new technological advances in the mining process that MSHA's regulations have not taken account for or have not been updated to take account for. And in that, what we're looking at, or what MSHA is looking at, and this is going to again be regulations that could be revised or modified that are typically included in these petitions for modifications. Now, one of the regulations or one of the requirements is that a petition for modification will only be granted if the agency determines that the alternative suggested by the company provides at least the same level of protection as the existing standard. So that is one of the elements that has to always be kept in mind when we're going through this process or we're making suggestions. There cannot be a decrease in any way, shape, or form of the safety or the level of protection offered by the actions. But nonetheless, it is another time when industry feedback is being sought on what regulations can be changed. The final rulemaking items, the first of which we're probably familiar with, is the examination of working places in metal and non-metal mines. And I'll focus on this one as opposed to digging into the other final rule, which is refuge alternatives for underground coal mines, because I think the majority of the people on today are going to be in the metal, non-metal industry. But if you are in the coal industry and want to discuss that other final rule, please feel free to contact me. But the examination of working places, and this has been a hot topic for a while now, and we can see that, again, it came out at the tail end of the Obama administration in June 2016. The final rule was published on January 2017, and this rule has got a significant amount of pushback from industry because it is going to reform how the metal and non-metal industry has to conduct workplace exams. It's going to make a significant change in that workplace exams will be required to take place before or during or as miners enter an area for their shift, which is a significant departure from the standard that we're under right now, which is it just must be done once per shift. And this is just, there's additional changes beyond that about notification of miners and record-keeping requirements that are a departure from what the industry has done to comply with the regulations for a number of years. So this is one that we have gone through hearings, final rule effective date for May, then for June, then for October, and now we are looking at an effective date of June 2018 on this regulation. So to see what happens between now and then, we'll have to keep tabs on what's going on. In October, the effective, they put in a stay on the effective date until June, and that also reinstated the existing rules. But at the same time as that stay and the new effective date, MSHA did make a couple tweaks to the rule, and that would be that they changed that regulation to proposed changes to the final rule were made that you don't have to do the exam before miners enter an area. It can be as miners begin work in an area, and again, that's going to be one where training in consistency is very important. The other change is they remove the requirement to document adverse conditions if they're promptly corrected, and then it said that the prompt definition is before any miner is potentially exposed to an adverse condition. So essentially, if something is corrected immediately or in the process of the review before workers enter the area, then we won't have to document that change or that correction with our other corrective actions that are going to be listed. So these are a couple areas of emphasis that I wanted to point out because they are different than what the final rule was halfway through this year, and they are relatively new changes in that last publication or regulatory publication. So another item that we talked about at the beginning is the increase of the civil penalties. And again, this is part of the Inflation Adjustment Act, and these are the annual adjustments for 2018. So we're going to see this continue every January, that there's going to be an increase in the penalties for MSHA, which is different than the years that we went without an increase after the Minor Act, which initially redid the penalty structure in Part 100. So, I know this chart isn't the easiest to read, but it is from the regulation itself. But what we're going to look at is the minimum penalty for 104A is going to increase just a few dollars to $132 for our minimum penalty, and that doesn't take into account the typical 10% reduction that you get for prompt abatement with the agency. Additionally, we're also going to see an increase in the maximum penalty, and that was $70,000 for a long time, again, since 2007 until 2016. When they did the Inflation Adjustment Act and applied that criteria, it decreased down below $70,000. Now it is above it this year for the first time since they put the Inflation Adjustment Act into place for MSHA. So the maximum statutory penalty for regular assessments is going to be $70,834. Additionally, our unwarrantable failures have increased in what those penalties are going to be. The D1s are now going to be increased up to $2,361, and the D2s to $44,721. My apologies. The failure to notify MSHA of a injury within 15 minutes is going to be a minimum now of $5,903, and that's an increase of almost $1,200 from what it was, and you also could be subject to the statutory max out. So we're looking at a minimum. That's why that 15-minute rule is so important, having those procedures in place to contact MSHA within that 15 minutes of becoming aware of a death at the mine, an incident that has a reasonable potential to cause death, or any other items listed as MSHA's definition of an accident in Part 50. We need to be aware of those. We need to have our personnel trained on them, and we need to be able to quickly and efficiently contact MSHA, because we don't want to get in the position that we're at 16 minutes and we call them, or 20 minutes, and albeit that sounds ridiculous, that's immediately looking at a $6,000 fine roughly. I know for a lot of people that number comes off as a surprise, especially those who have more experience dealing with OSHA. But for these parts, it is something to keep in mind. Additionally, an item that we typically don't see a penalty for is a 104B, or a failure to abate order. But MSHA can issue penalties for failure to abate, and those can be issued on a daily basis. So you're looking at a minimum penalty now a maximum penalty of $7,600 a day for failures to abate orders. The last two are, the standards that revolve around smoking, and those can be issued, one of the few that can be issued directly to minors. That penalty is going to be increased to $324, and then lastly, our flagrant violations are going to be increased to $259,000 per issuance. and those are specifically for those violations that qualify as flagrant, and therefore are not going to be subject to the Part 100.3 penalty point scale. At that point, they can go up and beyond that with the flagrant designations. So, with that, what are some areas to watch going into 2018 as we continue some possible changes? And I think one area to watch is impact inspections. Now, we probably have heard about impact inspections because over the course of the last 4 years or so prior to the administration change, there was a release sent out on a monthly basis by MSHA noting the impact inspections and their results for that month. And that would provide a list of the coal mines and a list of the metal non-metal mines that received impact inspections. It would discuss how many citations or orders were issued, were they SNS or non-SNS, and what was the reason for that issuance, along with other information. And that could be, enforcement history, or it could be enforcement history, or it could be due to rules to live by calculator rates, or it could be due to fatality or serious injuries. Those are the reasons that we typically saw impact inspections taking place. And when we had an impact inspection, you probably heard about these, sometimes they're referred to as blitz inspections, but MSHA typically showed up with a number of inspectors to your mine site and spread out and covered every inch of the site. There was probably someone looking at records. There was someone in each area, maybe more than one person in each area. So, since the administration change, the emails providing a list of what inspections took place on a monthly basis, those have dwindled. We haven't seen those for a bit, as well as since October, no impact inspections have been posted to the MSHA website. So that is an interesting development. It's something that we, could see go by the wayside. Many operators felt that it was largely punitive and did not serve a greater purpose. MSHA obviously had their reasons for implementing them when they felt that there was a pattern of noncompliance or a history of noncompliance at a mine. But this is an area that we want to keep on the radar for moving forward and make sure that we, kind of pay attention to it and see where we're at, because these were typically going to happen. The mandate was within a year of a fatality, there would be a impact inspection, or within a year of a serious injury, there would be an impact inspection. So, if those are unique circumstances that only apply to a very small fraction of the mining operations, but the other one that is something that we have been told to monitor is the rules to live by calculator, and what our rules to live by rate of enforcement is against our industry sector. And one of the repercussions of that was an impact inspection. So, I suggest we continue to monitor those situations, such as our rules to live by. We shouldn't just pack up and say this isn't going to happen again, but it seems to be a program that might be losing support within the agency, and we'll, have to keep an eye on it as we move forward. Another area is the Special Assessments Office. Now, if we are familiar with receiving MSHA citations, we get that proposed assessment in the mail, and that proposed assessment in 90% or more of this enforcement actions is going to be based off of that Part 100.3 penalty criteria, where we add up the amount of penalty points for our citation based on the designation for negligence, the designation for gravity, the designation for severity, and we add those all up, and then we look at the chart and say, well, I have 60 points, so now I'm going to get the statutory minimum, which is $132 moving forward. So special assessments is cases where MSHA can go away from that chart, even if we're not dealing with flagrant violations. They're still going to be capped unless it is qualified as flagrant by that statutory maximum of 100.3. but they're not going to be held in check by the chart. And the MSHA says that this is for cases involving extreme danger or willful violations. We typically used to see them only in situations of fatalities or serious injuries or high negligence or reckless disregard, unwarrantable failures. But now we're seeing them much more frequently, that special assessments are assigned. And, that could be whether it's just a high negligence 104D or a high negligence 104G, which is a training order, or for any citation associated with a 107A. Those are all going to be evaluated now for special assessments. Even just a 104A citation that is evaluated as high negligence or is a high negligence rules to live by violation, those are going to be looked at and have been in the last couple of years for special assessments. And so this is one way that operators get much higher penalties than expected for citations that, may not be as severe as that, because MSHA is going to do special assessments when they want to assess a higher penalty than regular assessments would give. So, for that example, the penalty points might say that this should be a $1,000 citation, but MSHA might send you out a special assessment citation for $25,000. So this is an area, though, that I think could be looked at, again, because it is largely punitive, and it breaks away from this very well understood program of how penalties are constructed. Or maybe MSHA will revise and provide guidance about how additional points and additional penalties are applied based in special assessments. But right now it's kind of a guessing game to see or to determine how MSHA assigns the special assessments. They also typically take a very long time to be assessed. So if something is being evaluated for this designation, you're not going to get the assessments for months, maybe even 6 months or more, depending on how many citations are in there. So this is an area that I could see MSHA looking at for changes. And again, that could be based on how special assessments is determined that it applies, or that something is eligible for special assessments, or how the framework within determining how many points are added, or how the penalties are developed in special assessments. Maybe some more literature on that breaks it down a bit more clearly and provides additional guidance. But it's an area that I think we may see less special assessments in 2018 moving forward. And like I said, hopefully some guidance maybe on how that program is going to continue if it does. Another area to watch for is the special investigations. And now these are broken down into two categories, but it's going to be discrimination and whistleblower cases under Section 105 of the Mine Act, as well as agent liability investigations under Section 110. Both of these special investigations, both of these types really exploded in the last administration. And the whistleblower discrimination claims, that was not specific to the mining industry, whether it was OSHA or whether it was the financial industry or the pharmaceutical industry, whatever it may be, whistleblower protections were bolstered and cases were pursued with a renewed vigor by the government under the Obama administration. If you look at the numbers, the amount of cases that MSHA itself took forward and OSHA took forward under the Department of Labor for alleged discrimination or whistleblower protections, quadrupled or more in a 12-month period during the past administration. And so this will be an area to, determine or to watch to see how is that pursued. In that time period, there was a lot of case law that was established, which really broadened the definition of protected activities or activities that miners can be engaged in, or that if they are engaged in are going to be protected. And the adverse actions were also extremely broad, meaning what the operator could do against them to qualify for discrimination. So to watch if that walks back any, or just to see if MSHA maybe increases their threshold for taking a case, because the agency in these situations is going to do an investigation. And at that point in time, MSHA will determine if they will take the case of the minor forward and represent the minor, or if the minor is going to have to do it pro se or on their own. And if MSHA takes the case on their behalf, they can also and typically do pursue temporary reinstatement of the employee, whether financial or actual, until the case is ended. And what that means is, if you terminate someone's employment and they make a discrimination claim and MSHA finds that there is some merit to this and they're going to take the case, they can petition the judge to require the operator to reinstate the employee in their previous position, or financially by paying them, even if you don't want them to come back, until all the cases resolved. So we'll see. Again, the administration or the agency really started taking a lot more forward in the last few years. We'll see if maybe that trend normalizes, but it is an area to keep an eye on. Similarly, the agent liability investigations under Section 110 of the Mine Act are also an area that we should keep an eye on. Now, when these were initially laid out, they were really for egregious situations where, reckless disregard might be the classification of negligence, or there was a very serious incident or injury or fatality. It got to the point really where anytime an operator received an unwarrantable failure, miners have to be prepared, or mine operators have to be prepared for the eventuality that this special investigation could take place. And it's willing to look at, was there aggravated conduct by an agent of management that MSHA wants to pursue additional action on? And that is, do they want to assess a penalty against the agent of management? Or do they want to even pursue criminal penalties against an agent of management? And that only happens in very rare circumstances, but it is a power that the agency has. So these are still being conducted at a pretty high rate, but, it's again an area where the evaluation process, you're going to go through an investigation. That investigation will go through the district level and then go up to national level for review. And, at that national level, is the criteria going to be reevaluated? Or at the level all the way down to the investigator, are they going to reevaluate what they look at in terms of this agent liability and what has to be done? Or are they going to reevaluate maybe how many violations are investigated? It's interesting that, these were, again, much like the special assessments, typically reserved for pretty egregious situations, and they really became the norm. And it'll be, interesting to see if that's walked back. I hope this is one area where, the agency maybe reevaluates what they're looking at, or the lowered designations perhaps that trigger special investigations moving forward. So I think those are some very important elements that we can look at moving forward in 2018. That's all I have for you today. So I appreciate everyone logging on. Please continue to check in on the MSHA Defense Report website, and I'll continue updating that. For our next couple, or our outlook for the next year, we are going to have 6 programs this year. Our next one will be on March 14th, where we'll discuss MSHA jurisdiction. And so you can feel free to log on for that. I hope you all can join us. If there's any questions, I'd be happy to take them at this time, or if it's more convenient, you can contact me anytime after the webinar. So I did receive one question, can we access the webinar in full after the fact? If you have registered, I will be sending out an email in the next couple of days with a copy of the presentation as well as a recording to the webinar. So yes, you will have it intact. And if not, it will also be posted to, if you did not register beforehand, it will be posted to the blog, as well as there's an archive of them on our FIRB website. So yes, you will have access to the full webinar. All right, well, thank you for joining today. Appreciate everyone logging on, and have a great and safe 2018. I look forward to speaking with you guys again in a couple months. Thank you.